What's a deposition and why do you need to go? Deposition is a court proceeding. It's kind of an informal proceeding, but there is a defense attorney who's there to ask you questions about your case, and you have a court reporter there who's also there to transcribe what's being said. Your attorney should be there as well, who's representing you to make sure the insurance company and their attorney are not asking you questions that are either illegal or misleading, or that they're abusing the process in some way to harass you or otherwise make your life uncomfortable. Depositions probably happen in maybe 80 to 90% of work comp cases. Typically, you'll see an insurance adjuster retain an attorney for that purpose, and the attorney's there to dig up dirt. Basically, it's their job to try and find some reason to either deny your case or cut down the value of the case by looking into your past medical history or other things in your life, like prior injuries, car accidents, prior work injuries, things like that. It's different than going to the doctor, because when you go to your doctor, you're not under oath. At a deposition, you swear to tell the truth under penalty of perjury, which means you cannot lie. And so the defense wants to ask you questions about your past when you're under oath, specifically because they know you're not allowed to lie. And if it turns out later that you were lying, they can use that against you. Normally, depositions are a compelled process. It means that if the defense attorney wants to take your deposition, they're legally entitled to it. And if you don't want to sit for the deposition, they can actually get a court order to do that. Usually, it's an informal process, and it starts with the defense attorney contacting the attorney's office to say, hey, we'd like to take your client's deposition. Oftentimes, we agree upon a particular date and set up the deposition. On the occasion that the injured worker does not want to sit for deposition, then the court will actually have to decide the issue, and that process starts by the defense attorney sending what's called a motion to compel, meaning they're asking the court to order you, the injured worker, to show up at your deposition. Now, I'd say with 99% of the time, provided it's the first time that the defense attorney is taking the injured worker's deposition, the court will immediately sign the order, which means officially it's not the defense attorney telling you now to appear, it's the court telling you to appear. And you can't ignore a court order. If the court has ordered you to appear at a deposition, you are responsible for attending. Now, if you're receiving things like temporary disability and medical treatment, and you actually don't go to a court-ordered deposition, you risk that either the case could potentially be dismissed, or at the very least, the defense going back to the court and asking them for an order suspending your right to collect benefits and receive medical treatment because you refused to cooperate and submit for the examination. So more often than not, we don't have to go that far, and clients are willing to sit for depositions. And most often this involves us, the attorneys, sitting with the client before the deposition to make sure they're adequately prepared, that they know what's going on. That way they're not stepping into a situation where they're uncomfortable and unfamiliar with the process. The deposition usually lasts a few hours and typically involves the defense attorney asking questions about their current medical condition, how the injury happened, as well as things like their activity of daily living, meaning the things that affect them, how their injury has impacted their ability to pick up their kids or take the trash out and things like that. And so generally speaking, it's not a stressful process, but it's still an important process, which is why we spend time with our clients explaining to them what it is they need to expect from the process and how it's going to be used in their case afterwards, which is typically means that the document itself, the transcript, is sent to the doctor for review, as well as it can be used in court proceedings for things like trials where there's certain issues that need to be addressed by way of testimony.